our next presentation, you've already seen Jonathan on your screen. This presentation is about the UAE trends in employment law. I'd like to introduce Jonathan. Jonathan advises numerous multinational companies and regional powerhouses on international transactions, company formation, agency and distribution, joint ventures, and corporate governance in the UAE, GCC, and the broader MENA region. And it's very interesting to me, but Jonathan is a fluent Arabic speaker, and he frequently manages complex, contentious matters in the region, including arbitrations, local litigation, internal investigations, compliance reviews, and executive level employment. So thank you very much, Jonathan, for taking out the time and presenting on this topic. If you would like to share your screen and take it forward, that would be great.
Thank you very much, Rahul, and thank you to Hardeep and Ali for the very interesting presentation. Thank you especially to Ali for the lead-in to this discussion on employment today. That was very kind of him. Thank you. Before I start today and get into the presentation, I want to say that employment law in the UAE is fairly straightforward, and it's an area that is a core competence for most in-house counsel. Having said that, it's an area where an ounce of prevention is worth a pound of cure, and having external counsel get involved at various stages in the employment life cycle is very important and can be very valuable. And I'll just say from the outset, I think places where external counsel like us can be helpful are at the pre-onboarding stage, when you're going to bring somebody on at the executive level. You want to make sure that you put in safeguards for the company. Exits, of course, and we'll discuss that today. Investigations, when certain issues arise, whether that's violations of sanctions regimes, other kinds of internal investigations, and then more generally policies. Coming to a firm like ours to make sure that you have really good, strong policies in place, an employee handbook, etc. These are the kinds of things that I think external counsel will be well served to retain external counsel for these sorts of things. Just briefly about the firm, we were established in 1999. We have 9 offices around the region. We're an international firm, but built for the region with a strong regional focus. Our lawyers speak all the languages of the region, and we assist mainly multinationals, but also regional companies with work in North Africa, the Levant, as well as the Gulf. So I'm going to give a brief overview of what's new. And as you know, in the UAE, there's always a lot of chatter about things that are coming, new regulations, new legislation. How these things actually come to fruition is another story altogether. Before that, Rahul, we're going to ask folks. I should just say we'd like to be interactive today. I love to hear myself talk, but I also would much prefer to interact with the folks on this call today. So we're going to have poll questions, and we're also going to have a Q&A. Please feel free to stop me and ask questions in the presentation. Don't be shy. So Rahul, if you could please pop up our poll questions now, that would be great. So first, have you had a labor and employment issue in the UAE in the past 12 months? Has it in the UAE and in the GCC? Yes or no? And then if anybody wants to say, they don't have to, but in the chat room, what have been the major issues that you face or are currently facing? Give a few more seconds and then close. Rahul, should we, are the results of the poll in?
Yeah, just 10 seconds more. I see people are still replying.
Lovely. So I think this confirms what we all think, which is that this is a bread and butter issue that falls across General Counsel's desks on a regular basis here in the UAE. As a regional hub, it looks like less of you have had GCC-wide issues, but at least close to 1 in 4, 1 in 3 have had some kind of regional issue this year. We'll talk about regional things briefly while we go ahead. So in the UAE, let's just move quickly to what's new. And what's new largely is a result of COVID. Coronavirus has led to significant changes in the relationship. These have phased out as I think work life has gotten back to normal in the UAE more quickly than in other jurisdictions. But this was all as a result of Ministerial Resolution number 279 of 2020. And the goal was to help companies and their employees come to grips with the pandemic. So what did this allow? It allowed companies to put in work from home. This is one of the things that's happened. Now, again, as we discussed, there is a return to office, and so employees can resist this work from this return to office if they'd like, but again, they have to have a valid medical reason. And so increasingly, we're seeing companies here return to full employment back in the office. Paid leave. This was employers were allowed to specify dates that employees had to take annual leave. It confirms that this can be approved unilaterally, but it calls for some kind of agreement. And the resolution actually was a little bit disappointing, I think, for employers in that it sort of half mandated things, but then ultimately said, no, you need to have approval from your employees. It allowed onshore employers to mutually agree periods of unpaid leave. And it also allowed for parties to mutually agree to a reduction in salary, as well as a permanent reduction in salary. Again, those had to be by consent. I think we heard of numerous and participated with our clients in numerous temporary reductions, unpaid leaves, et cetera. From our experience in the market, most companies are back to full payment, are not furloughing employees any longer. And so a lot of these things that came in place in the last year have sort of just the nature of business has made them not obsolete, but less relevant. Redundancies, again, less relevant than they were. I'm going to go now to something that just came out. It's a little bit more recent, and this is Projects of the 50, Emiratization. Now, these are announcements. They have not gone into place, but these are things that I think we all look at on the horizon. They've been discussed if you've been in the region, if you've been in the UAE for a long time. So there's a push on Emiratization, and particularly on moving Emiratis into the private sphere. Among this is the apprentice program, so train to hire, vocational training programs for Emiratis in private and semi-governmental organizations. And supposedly there will be financial incentives linked to hiring Emiratis. There also, we understand, will be recruitment targets. There are other countries that you may be familiar with, Saudi being the main example, already have these in place. But private sector companies in the UAE are supposed to ensure that they have 10% of the workforce Emirati. And again, this should be graduated, 2% each year. There is some budget that the government is looking to put into this and to help subsidize private sector companies. Again, I think, how much of this comes to fruition is another story. And then unemployment benefits, again, will be extended to Emiratis who are in the private sector. Now, another new development are all of the remote work and different visa schemes that have been into place in the last year. And I think, these have all come into place with the goal of making the UAE an attractive and competitive place to do business in a post-COVID world, and also to take advantage of some of the remote work opportunities that COVID brought about. So this remote work visa is particularly designed to attract folks from elsewhere to the UAE. Basically, it's a one-year visa, self-sponsorship. It's about $300 a person, plus processing medical insurance. You have to show that you have a valid source of income from an employer or from a business outside of the UAE. Once you get this, you can obtain services, do utilities, medical, schooling, housing, etc. So this is designed to attract employees either who can work from anywhere or business owners to the UAE. Other visa schemes, pardon me, are the Golden Visa. This has been around. I think it predates COVID, but basically this is a long-term residency visa for highly qualified investors, white-collar professionals, those who have made major contributions to the UAE. It's a 5 to 10 year visa, and this is I think designed to put Dubai on or the UAE in general on a track with places like Singapore and other sort of regional hubs around the world that have more attractive long-term residency policies in place. The other recent visa is the Green Visa, which basically bifurcates residency from employment. We'll get into in our presentation here. Generally, residency is linked to an employment relationship of some kind. But this is for skilled employees, skilled workers, investors, business people. It basically is a 5-year visa that allows you to remain in the country, and you can sponsor parents, children. It also gives you a longer period to renew documents. And I think the main benefit here is, again, not linked to employment. So it gives you a right to remain here without having an employment relationship with a legal entity, a company. Finally, we have a freelance visa, which has been announced at the federal level. We don't have a lot of information on this yet, but we assume it's going to be similar to freelance visas, which are available in free zones, and basically lets people have a visa that permits them to provide services, professional services, media, etc., marketing to a number of clients without having an employment relationship. So, it's supposed to encourage small and medium-sized enterprises, solopreneurs, these kinds of things. We have a scenario here which probably will be easy for all of you, and is a little bit irrelevant post-COVID, but we'll discuss it nonetheless. Ellen's employer is advised that her salary is going to be reduced by 25% for 3 months. She consented to the reduction, and she signed an addendum to her employment contract. After 3 months, it was further reduced without warning. Her employer didn't seek her consent or apply to the ministry. She's not aware of her options. She's receiving a further reduction for a period of 6 months. In the Q&A, or does anybody want to point out various issues with this? I'm happy to answer, but I'd love to hear your thoughts. All right, I see that you're all shy. I'll just say, look, the main issue here is that these provisions that were put into place had to be with consent. Ellen here, the second reduction, the third didn't have consent. There wasn't notice to the ministry. These provisions were put into place to protect employees. And so as an employer, as an in-house counsel, whenever you're negotiating in a post-COVID world, reduction, whether temporary or permanent, the rule of thumb is that you need to get consent, you need to get it in writing, and you need to amend whatever documentation you submitted either to the Ministry of Human Resources or to the free zone to properly reflect those consensual changes to the employment relationship. We're going to move on to a GCC focus just briefly. And I know this is UAE, but so many of us deal with cross-border issues in the GCC, and so we wanted to give a little bit of attention to this today. Rahul, can you put up our poll question so that we can get responses to this before we move forward, please?
Yeah. Coming right up.
So have you dealt with a cross-border secondment in the GCC? And then how do you manage this? Any thoughts on how to manage this? If you want to put into the Q&A, the question box, that would be great.
Right, I'm going to end the poll and show the results on the screen. And we're also getting answers in the chat box, Jonathan.
All right, so about 1 in 5 of you have a cross-border issue. Wonderful. So that this will be relevant to 1 in 5 of you, and interesting, hopefully, to the remainder of you. So just as an overview, and I'm happy to share this with you, countries in the GCC generally have similar or comparable labor law systems. If you look here, probation is generally 6 months, or between 3 and 6 months in a few cases. Working hours are about 48 hours, 44 to 48 hours a week. They all have overtime provisions, similar vacation provisions, similar gratuity provisions, and similar notice period provisions. So it's not fair to say that your UAE knowledge carries over 1-to-1, but there is continuity in terms of labor law across the Gulf. Rajesh, thank you. We will, for those who reach out to us, we're happy to share this chart and other elements of the presentation. So what are some of the major labor issues that are unique to the GCC? It's a multicultural market, and so you have folks from many different legal, cultural, economic environments who are all here and all coming from a different point of view. This leads to lots of different problems: sharing of information, what people deem to be confidential, what they don't deem to be confidential, issues of embezzlement, collusion, corporate morals, what may be a no-no in one place is not in another, and also issues of what's deemed to be harassment, sexual harassment, power harassment. The laws are frankly don't address these areas in great detail. So that's another issue. Well, again, embezzlement, these kinds of things could require an internal investigation. So we have a question: is this the same for all nationalities? And the issue is, if you're in the private sector to the labor law, i.e. not in the governmental service, then yes, this would apply to any person in the working across in the private sector. So what are ideal strategies for dealing with these kinds of issues in the GCC, but anywhere? Training and evaluation of employees, putting good handbooks and resources into place, communication, and having fair and open procurement procedures and audits. Thank you, Rahul. So often folks in the region, folks in Dubai or the UAE will, will hire independent contractors in other jurisdictions, whether that's the GCC or elsewhere. So you hire a business development person in Egypt or Saudi, etc. This is a key issue. If they are hired as an employee in the UAE and they have a UAE employment contract with your company, they will be subject to UAE labor law, and they will be able to seek end-of-service benefits, all of the statutory benefits that you enjoy in the UAE through UAE courts. Now, maybe in practice that somebody in Pakistan is not going to do that, but this is a risk that we always recommend that employers here avoid. So if possible, when you're hiring people in these jurisdictions, either do so through a local subsidiary, a local manpower provider, or if local law permits, an independent contractor. But the key point here for you is, if possible, do not put these folks on an employment contract here with a residency visa, etc., so that they are entitled to benefits, statutory benefits, and contractual benefits under UAE law. How can we access the recording at a later stage? Rahul, I think, will we be sharing this with folks outside of after this presentation? We will, correct?
We will have the whole video of today's presentation available on our YouTube channel later on. But I do insist, if you are here, please, the presentation is here, and you can always get in touch with Jonathan later on by email. He'll be happy to share.
Yep. We're happy to share this with you and to answer questions or general questions after this presentation. So we talked a little bit about independent contractors, things to avoid there. The other issue is secondment agreements. When you have an employee here who you want to send out to work in a place like Saudi Arabia or Kuwait, and this frequently happens, where a distributor will say, hey, we want a business development person, or we want a maintenance and repair person to come out and to sit in our shop. These are very common. The thing that the issue is that they often give rise to dual liability for both the employer and the distributor or the person who they're being seconded to. So the ordinary relationship, as we see here on the left, is that the employer has a secondment agreement, they send the employee out and they continue the employment relationship. Now, that doesn't work in the GCC. Why? Because the place of secondment, the distributor, et cetera, has to then issue a residency permit and enter into an employment relationship with that employee. So what we frequently recommend be done is that the employment relationship with your employee either be terminated, which is ideal, or if not possible, paused or suspended with clear contractual language in place that has a clawback if they do try to request benefits in multiple jurisdictions. Then a service agreement in place with your distributor in another jurisdiction where you pay salary and benefits and they maintain an employment relationship with this employee. Once the secondment is over, they come back and they pick up again. It may not always be ideal or easy to sever that employment relationship, but there should be some paperwork in place that that clearly spells out that the employee cannot, quote unquote, double dip, receive benefits in both locales. And we often see that this occurs. I would say the risk is not often realized, i.e. that a person files suit in Saudi Arabia and the UAE, but there may be claims that arise and can cause real headaches in multiple jurisdictions. Can an employee work for a subsidiary with a parent company visa? Well, I guess the question would be where. Generally, this is with Swana. Generally, in Dubai and the UAE, if there is a common owner, common shareholder, this can be done. It's always better, of course, to have the employee be under the employer. It's because there are SNAP inspections and reviews of employees on site. But it's generally understood, and particularly if you have a national service agent, you share a national service agent if it's a branch. These kinds of arrangements may be permitted. Okay, I'm going to move on. Any questions about GCC? I know that's a little bit very general, but the idea here is that if you're sitting working for a multinational in the UAE, the two things you really need to make sure of is when you have independent contractors or folks in other jurisdictions, they aren't able to form some kind of employment relationship that would entitle them to benefits here. And if you're sending folks out into other markets, that you make clear who is responsible for what contractually, and try to prohibit double dipping or confusion about whether you or your distributor or partner in that other jurisdiction are liable. We're not going to have a poll now. I'm going to go right into UAE labor law. If there are any questions about GCC that you'd like to ask, maybe now would be a good time to raise them. I'll wait a few seconds and then move on to our overview of UAE labor law. All right. So this is why you all came today. Oh, we do have a. In Dubai, how are secondment agreements possible? What are the provisions to be included? Thank you, Kartika. That also is a very broad question. What kind of secondment are we talking about? From a free zone to an onshore distributor? Look, generally, and I'm going to get to this in the UAE labor law presentation, generally these secondments are going to require, if you're onshore, you can get a temporary work permit and go ahead and work, be seconded to a partner company in the free zone. Moving onshore from a free zone company is more difficult, but not impossible. But it is a very location to location specific inquiry because we have 40 free zones. secondment with temporary work permit, who will be held liable for labor? So we have another question here. In case of a secondment by way of temporary work permit, who will be held liable for labor dues? So if we're talking in the GCC, somebody is entering into a new labor relationship in another jurisdiction, then and you've cut off or suspended or terminated your employment here, then the distributor or whoever it is that you're working that's holding that employment relationship in the other jurisdiction will be responsible. Here, if it's a temporary work permit, you've gotten approval for your staff to work in DAFSA or JAFSA, that's not an employment relationship. The employment would continue with the employer of record, you, and you would be held liable for labor dues, etc. Is there a way to determine which company owns the work product of the seconded employee? Thank you, Miriam. I think this is something if there were issues of intellectual property, and I assume that this is what you're referring to, you would need to spell this out both in the employment contract, so that you would have ownership of that intellectual property, it would be assigned to you, and that the employee would undertake any acts necessary to assign that IP. You would also then need to have an agreement in place, and preferably in your service agreement with your distributor or this party that you're seconding this employee to, that any intellectual property that the employee develops while they're with that entity would also belong to you. And those would be contractual arrangements that you would put into place both with your counterparty in the other jurisdiction and with your employee. So I would say I would not leave that to mandatory provisions of law. I would make sure that we have clearly drafted provisions in our contracts that cover that. Thank you, Miriam. So I'm going to get right into it. UAE labor law, 1980 was when it was promulgated. It's one of the oldest laws in the UAE. It applies across all the Emirates and free zones in principle. It has carve-outs, so government employees, the military, domestic workers, these folks are excluded. Onshore, and we've talked about this a little bit already, the Ministry of Human Resources and Emiratization, or MOHRE, is the main regulator. And each free zone, the free zone authority has its own labor regulator. And so there are different regulations, different employment contracts from free zone to free zone. JAFSA and DAFSA here in the UAE, here in Dubai, pardon me. I would say also DDA, the Dubai Development Authority, have the most robust labor regimes of the various free zones. DIFC and ADGM, which we're going to touch on very briefly if we have time, perhaps not. They have independent employment law systems that are common law based and that are very different from what you see onshore and in the other free zones. Labor law is generally employee friendly. The following issues require careful attention for employers: overtime, vacation, and I think labor contract termination. We have here very briefly, there was an anti-discrimination law that was put into place in 2015. It focuses on stopping religious extremism and discrimination. There is not a comprehensive harassment law or other kinds of modern statute on these sorts of things. Labor law has been amended multiple times, and a new one has been discussed. We don't have one yet. So how do labor contracts work in the UAE? There's a standard form labor contract with the Ministry of Human Resources or the various free zones. It sets out basic terms, remuneration, commencement date, term, etc. Now, an employer, sometimes there is an offer letter or a contract that's provided prior to this. There also may be a supplementary agreement that's put into place that has terms on things like confidentiality, bonus provisions, participation in stock plans, etc., that are more complex and outside of the bounds of a standard template form labor agreement that we have here in the UAE. Work rules, some companies have them. We recommend that all companies have an employee handbook. If you don't, please get in touch with us afterwards. We're happy to help you draft one. These should cover rules for employees internally. Again, the goal should be to set rules where there are no provisions of law, confirm and give additional insight into areas of law that there's a little bit of gray. So I would say, for example, suspension and disciplinary penalties are in the law. They're not terribly clear, and so it's really good to have provisions on that. It also sets out management rules for the multicultural workplace here in the GCC. I'm going to go quickly over these things. I think most of you know these, but this is an overview. So, let's just talk about basic rights, basic provisions under the labor law. So after a year of continuous employment, 30 calendar days of annual leave, that can be divided up into 2 different tranches by an employer. It really depends on the kind of employment that's going on. This is a major requirement. Gratuity, it's basic salary paid through the WPS system, and that's again after a year of continuous service. We're going to get into a breakdown of that a little bit later. We have another question. Should the employee manual be attested by the Ministry of Labor? Thank you, Darian. Yes, the law requires, or the statute does state that. Also, things that you post in the workplace should be confirmed by the ministry. In practice, we see that this doesn't really occur. But ideally, yes, and I think we would encourage folks to at least file these with the ministry if possible, or the relevant free zone, so that they can say that they've complied. Working hours and overtime, so it's 48 hours a week. This can be extended up to 9 hours a day for employees in commercial establishments, hotels, and restaurants, watchmen. Termination, unless a different period is stipulated by contract, it's a minimum notice of 30 days. Now there was a ministerial resolution that went into place several years ago. Notice period should not exceed 3 months. And there is a compensation in lieu of notice for either party if the terminating party fails to follow the notice period. So that's the full amount if you're the employer, if you fail to follow it, and it's half if you are the employee. Is the employee handbook a mandatory provision? No, Kartika, it's not a mandatory provision. It is something that we find is a lifesaver when there is an employment dispute that progresses to court, because you're able to state that if an employee makes certain claims, and those are covered in the employment handbook. So, for example, bonus. An employment handbook can say that across the organization, an employee is only entitled to bonus if they're employed by the company in December of the year in which the bonus is accrued. Well, this is a very nice provision to have if you have an employee who's claiming bonus when they were terminated halfway through the year, because it makes clear that there was an internal arrangement between all of the employees and the employer about when bonus is accrued and when it becomes due. So it's not a mandatory provision, but I would say sophisticated organizations have these in place, and they often save significant amounts of money because they're good pieces of evidence to have when a dispute progresses. I'm going to getting a little bit short on time, so I'm going to move beyond this. But we have basic things here. Emiratization we discussed. There is Tautine. That I think the main thing to point out here is Tautine. You need to now run all of your new job postings through Tautine before you go ahead and hire an expat. I think this is going to become an increasing issue based on what we've seen, the 50 plan, et cetera. And we should see more active MOHRE introduce new emiratization requirements, or maybe not new, but more oversight over emiratization requirements. So it may not be sufficient anymore to post in Tautine and then not actively interview. It may be that you actually really need to make a good faith effort before you can hire expats. We have an anonymous attendee who's asked us, can an employer refuse access to the office to non-vaccinated employees? And I feel like this is maybe a ringer. We actually were asked to submit a couple of questions, and my associate and marketing manager, who I have to thank both of them, Taskeen and Chrissy, for putting together a great proposal, a great presentation today. They both raised this. So I think the answer here is we need to tread carefully. But if there is a compelling reason to refuse an employee access, and public health is one of those things, then you can certainly ask somebody to stay from home. So can you mandate? There is not a clear provision in place on this, but there may be public health arguments to make to refuse someone access. We have another question here. Disciplinary termination not qualifying for termination under Article 120. Is the employer expected to provide several warnings before termination, or can termination be done with 30 days notice? So we'll get to this hopefully a little bit later, but I will just answer this in the least lawyerly way possible. If you terminate for convenience and you have a 30-day notice period and you follow that, then no, there's not a reason to give warnings. Warnings can be helpful because there's this issue of arbitrary dismissal, which we're all, I'm sure, aware of. Arbitrary, the Articles 122 and 123 of the law states that if you terminate an employee for an unjustified, without a business reason, without a valid business reason to do so, that person can be entitled to up to 3 months of compensation salary as determined by the relevant judge, right? So if you don't provide warnings, if you don't provide a justification, put it in the file for performance, and you document it, there is a risk, and we all know, every employee here knows this, they will all claim arbitrary dismissal. There's a risk that arbitrary dismissal claim is seen as valid by the courts, and the judge provides between 1 and 3 months of termination compensation to the employee. Thank you, Amjad. Any plans for a mandatory social security system for the private sector? No, not that I know of. This is, in my opinion, a no-brainer because we have all the time companies that don't properly accrue, and then you have poor employees who don't ever see end of service benefits. It would also be, as we all know, a fantastic way for governments in the UAE to have revenue to invest ostensibly in their own projects. So I don't know why we don't have this, but this has been talked about for years, but nothing concrete. But it would be great to have a mandatory social security system where companies pay on a monthly basis, and the government then backstops payments out to employees when they're terminated. I think we got to this, Rajesh, the question about arbitrary dismissal. I'm happy to have a conversation on that offline or via email. Is Emiratization affecting the free zone companies? Thanks, Marilyn. Yeah, that's a good question. I think it's too soon to say. These announcements of 10%, et cetera, are brand new. I think the free zones have always been a carve out in terms of onshore regulation. So I would say less so. But the goal is to increase private sector participation of Emiratis in the private sector. The reason we want to do that is because obviously government employment is a kind of subsidy. The government here has a far-reaching vision. They want to have their citizens be involved in cutting-edge work and be able to build and grow profitable businesses, sustainable businesses here. So I think it's too soon to know, but something to look out for. I would imagine that free zones are going to be a place where this is less important than onshore. PROs, I think we all know about PROs. I don't want to get into great detail, but these are the kinds of folks that make government submissions, visas, cancel. A couple of important things here. You don't have to employ a PRO unless you have a certain level of a number of employees, or unless you're engaged in certain sectors, you can use an outside contractor. If you're in one of those, if you have a threshold level of employees, it's rather high, or you're in certain sectors, you do need to have an Emirati. But you need to employ your own PRO, but that's pretty rare. Working hours and overtime, we discussed this. I can get into it in more detail if you guys would like me to, but I'm going to skip it in the interest of time. Paid vacation, again, we discussed this 30 days per year, and it can be divided up to 2 times. One thing here that I do want to talk about, and I think is really important, we see folks who gather together paid vacation over a 2-year period, and then when the employer goes to terminate the employment, there's basically 2 months of compensation that's owed. So 2 things to point out here that I think are really key for employers, for in-house counsel. One, and this is another area where I think the handbook is important. One, use it or lose it provisions in contracts and in the handbook. That is, the year that you accrue it, you must use all of it or close to all of it, and you can only roll over a certain amount. I think that's a lifesaver for a lot of companies. It saves a lot of money at the end of an employment relationship, and it should be in any sophisticated company's handbook or employment contract. The other thing here that's really key to point out is you cannot force an employee to take vacation during the notice period. You can try, but this is something that's not going to be looked at kindly by the ministry or the courts. Once you issue a termination notice, that basically freezes annual leave unless it's already been agreed upon and documented. And so, again, use it or lose it is a really good thing to make sure that you put in. Inspection in place of employment. No question here. Can you implement a use it or lose it policy for leave days in the UAE and only allow carry forward each year of a set number of days, and all other leave days are forfeited? Thank you, Tinas, for the question. You're right above us. It's nice to see you again. Yes, you can implement a use it or lose it policy and allow a carry forward. Basically, the principle behind this is that an employer can set the leave date and require the employee to take leave. So it should be clear in the handbook or among your HR professionals in your team. They need to instruct their employees that they must take leave. If they do not take it, they can only carry through a certain amount. And what if the employer rejects the leave? You have a right as an employer in the UAE under the labor law to place them on leave. They only work if you need them or require them to. So I think you can unilaterally impose leave, paid leave, I should say, not unpaid leave. So yes. Does hiring a GCC national, not an Emirati, count as a percentage of localization? So we don't have the same thresholds as we do in Saudi. It's not as important of an issue yet. I would imagine here, no, it's going to be Emiratis. I may be wrong, but again, the goal here is that of the 1 million+ Emiratis here, the government wants as many of them as possible gainfully employed in the private sector. So, hiring a Bahraini is not necessarily going to help with that. Thank you for the question. Inspections. Look, it's just important to know that the Ministry of Human Resources and the free zones are out there. They do make inspections. They come to our offices. They come to your offices. They will fine folks if they find people who aren't supposed to be there. Key point here is temporary work passes. If you got folks working onshore who need to go to the free zone, you need to make sure that your counterparty there, whether it's a client or a sister company, has a temporary workplace for them, and put that into place. It's important. I have to say that I haven't seen a ton of fines, but it happens. Rahul is telling me that I've got 15 minutes left, and I want to get to the meat of this. So I'm gonna move through workplace management, terminating labor contracts, labor courts, these sorts of things. We're happy to share this with you, and we're happy to do that. It's not a problem at all. I'm going to move now to the meat of the. I guess this has all been meat, but to what I was thinking of as the meat of this presentation today, which is non-competes and confidentiality and employment terminations. And these are places where I really think that external counsel is so important. Because we deal with these, we have a range of experience, we know what's going on in the court. There isn't a principle of stare decisis, of binding precedent with courts here, but we know, and for example, we've seen in the past year, that court quality of decisions, in our opinion, has decreased reasoning, and they've been more employee friendly. So we see trends, granted they're anecdotal, but it's something that as an in-house counsel, you may not have exposure to in the same numbers that we do. So the first thing is confidentiality and non-competes. Why is this so important? Look, we're in a data-driven world. This is a key for businesses nowadays. Competitors battle for the same pool of clients. Relationships are key to success. Proprietary information is priceless. It's how we battle and win in the 21st century. So who should be subject to your post-termination, non-compete, and confidentiality obligations? Your executive level staff, C-level staff, key sales and business development staff, your key technical staff, and staff with knowledge and access to sensitive information and key clients. You don't need to put in extensive confidentiality and non-compete obligations for low-level staff or employees. Even I would say, a junior business development person, unless they really have key relationships, that's somebody that you want to be a little bit, have a little bit of a different approach to. So non-competition generally. Labor law permits non-competes. You have to meet these 5 requirements for them to be enforceable. The employee has to be over 21. The restriction needs to be limited in time, needs to be limited in geographic place and scope, and it needs to be for the legitimate interest of the employer. Courts are unlikely to redraft an unenforceable clause to make it enforceable. You've got to get it right when you draft it and have them sign it. They can be drafted broadly, and they can include any of these elements: joining a competitor, starting your own competitive business, approaching clients and contacts, poaching employees, i.e. non-solicit. And I'm going to get to this. Look, these are important. They're very difficult to enforce in the courts in the UAE. The more narrowly tailored they are, the more that you mention a specific competitor or group of competitors, the more likely you are to be successful. Even with that, we've had incidents within a free zone where employees have moved from one competitor to another, and that competitor was mentioned in a non-competition provision. The free zone still didn't take effective action. So while this is key, it still is very difficult to enforce. Look, confidentiality is governed by the labor law, the civil code, and the commercial companies law. Employees need to know that they need to keep industrial and trade secrets confidential, and there are provisions to enforce this. It can also be through criminal complaints, the penal code. And if it almost certainly now will be through the internet. The cybercrimes law is going to enhance punishments. And so this is something where you really potentially do have teeth. If you have a person who is downloading client lists, confidential information, data, etc., this is something where you might want to strongly consider filing a criminal complaint and using the penal code and the cybercrimes law as a way to try to stop this kind of behavior. As I said earlier, enforcement is challenging. The ministry, free zones, they can block visas. They don't do it. They think it's a private dispute, and they really don't like to get engaged. UAE courts take a long time to run decisions. The key thing for in-house counsel here to know, there is not injunctive relief. And so it's not like in the States or in common law jurisdictions where you can go on a Monday morning and slap a TRO in place and enjoin somebody from going somewhere. No. Again, one aggressive option, and we counsel clients on this a fair amount, work with colleagues, a criminal complaint. It's not pretty, it's not something that I would prefer to do, but it seems to be one of the only effective tools here if there really is a serious breach of confidentiality or of competition. No quick fix. So again, as I said at the beginning, ounce of prevention is worth a pound of cure. One of the things that we're gonna discuss is making sure that they are properly tailored. So our keys here: duration, 6 to 12 months. Location, UAE only, even better, Emirates specific, Dubai, Abu Dhabi. Name the sector, name specific competitors, name specific product lines. Because you don't have injunctive relief, you might want to consider liquidated damages. This would at least give you a claim in a civil suit to recover, quantify the harm and to recover some of the loss. Now, again, consider having key employees sign an NDA with a choice of law provision in a jurisdiction that allows injunctive relief. That may be AFC or England. That may be an effective approach. Again, the stronger the clause, the less likely you're going to have issues with enforcement. I'm going to skip over this, but we're limited on time. Your IT system is critical. It's really important that you work with IT professionals in your team to discuss ways to monitor the movement of unauthorized movement of data, and to make sure that you have some IT provisions in place that makes the likelihood of theft that's not detected very low. I'm going to skip over our non-compete scenario. I think, Rahul, we have a limited time, so I'm just going to go to managing employee exits. This is something that's really important for us and for folks to know about. So UAE law makes it relatively easy for employers to terminate. You can terminate during probation period without a cause and with basically, without a justification, without cost to you. You can terminate for cause in limited cases, and it's mainly Article 120. That's basically it. We haven't gotten into that because we haven't had time, but there are very limited cases in which you can terminate for cause. You can terminate without cause, and we discussed this issue of arbitrary dismissal. Again, for unlimited term, 30 days notice minimum, up to 90. For a fixed term, and this is a place like JAFSA, you have a fixed term agreement, you have to pay to the end of the agreement or 3 months, whatever is less remaining. So fixed term agreements, you really, if you use them, you need to either do them for a short duration, like a year, or make sure that you're going to keep that employee for the period of the term. Look, nobody likes to be fired. We always recommend structuring a termination as a voluntary separation. Why? It allows the person leaving to have dignity and honor in their exit. And I find 99 times out of 100, when you treat an exiting employee with respect, the process of termination is so much better than when you don't. So, an employee can be terminated without cause. You need to pay your end of service gratuity, your unused vacation, payroll, any benefit to return country, and additional compensation. And often we've seen, if there is an amenable exit, we want to avoid going to court, that the employer will offer between 1 and 3 months in recognition of this risk of arbitrary dismissal to go ahead and allow a way out for the employee. Again, given the cost and hassle of litigating these cases here, it's often makes sound commercial sense. I hate to say this as a lawyer, but it's better commercial sense to offer a severance package that gives you almost everything that you could get under statute than going through with a criminal, with a labor case. Pride is important. We discussed this. Allowing folks to leave with dignity, it reflects well on the business. It also reflects well on them. There are employees who will reject that, no matter how thoughtful the termination is. So when that happens, you have to be prepared to defend and to think about how to do that. Let's just talk briefly about the judicial process. First, before there's a complaint, before you go to court, the employee must go through either the Ministry of Human Resources or the relevant free zone authority to try to mediate the dispute before they file a formal claim. If you cannot successfully mediate it, the Mohre or the free zone will issue a reference to court. There's no court fees for employees filing below a certain threshold. And so it's often as an invitation for employees to file. They think, why not? I'll just roll the dice and see what I get. Almost always, courts are going to appoint an accounting expert that's from a roster of experts, and they will look at the facts of the case and issue a report that the court then uses to issue their decision. We're talking about 3 to 6 months at the court of first instance. I've seen that go far beyond a year. I've had cases with complicated appeals to the Court of Cassation that can go up to 3 years. So this can be a lengthy and expensive process. So when do you settle? I think this is, your managing director is asking the in-house counsel, what do we do? You need to price in the cost of litigation. That's hiring a local litigator, having a firm like us involved in termination and advising, and see whether the costs make sense. It may make sense to offer the full package, i.e. everything that they could get under statute, because the cost of litigating in terms of time and hassle and money is just not worth it. Again, sometimes you have to fight the claim. And we've seen instances where employees demand 2 or 3 or 4 times what they could possibly get under statute. It also may be that you want to set a precedent to your employees in your shop. Hey, we're not going to be blackmailed every time somebody leaves. So I think these are key things to consider. I would say that more often than not, and I'd be interested to know your thoughts on this, more often than not, it makes sense to settle. It's only when you have an unreasonable employee that you're forced to move forward and to proceed. I'm sorry, in my haste, I missed this. We have questions for termination, and I'd be interested to know if we could, Rahul, go through these quickly, and then I think open it up for questions since we don't have a lot of time left.
Yes, absolutely. We have 2 minutes, so you will have to make it quite.
Let's do the poll, and then we'll go from there. So, who handles executive level terminations at your company? Is it HR, the general counsel, CEO, a combination, or somebody else? And then we're curious to know, in the UAE, are you more likely to settle or let them proceed to court? When you do have a high stakes termination, do you hire external counsel or do you manage it internally? Yeah, very interesting. So HR handles terminations 50% of the time. Others, it's a combination. I would assume that's the PC and CEO and HR. Almost everybody says, let's settle. And I think I would agree with you, unless you really have to. Settling makes sense most of the time. And then final question here, who handles high stakes terminations? External counsel or internal? Slightly more internal, but some external. We find that our counterparts inside of a company are almost always very well able to handle these things. But it sometimes makes sense, especially when you have combative employees, to bring in external counsel to assist with this. Rahul, I think we've got some questions, and then I don't know if we want to just open it up to questions now.
We can answer one question because it's already time.
Sure. All right. So I think, please advise a calculation of gratuity should be based on 365 days a year or 30 days in a month. It's a continuous year. I believe it should be 365 days. We see this, we see people doing different calculations with 30 days. It generally is pretty minor difference. I would tend to go with what favors the employee if there is a discussion, so that you don't make a big deal out of a few hundred dirhams.
Brilliant. Well, thank you very much, Jonathan. I know we keep getting questions. It's a testament to your presentation and how important this topic is to in-house counsel and everybody who has joined in today. So if you have any further questions, or if in case your question hasn't been answered, I'll share Jonathan's email in the chat function. You can always just Google Jonathan Noble AMERELLER and you'll get all the details right away. So Jonathan, thank you very much for that great, impressive presentation. And hopefully you'll receive a lot of emails from today's attendees asking you for your slides and also more questions. We'll keep you busy.
Happy to be of assistance.
All right.
Thank you, everyone. Have a great evening.
Thank you so much.